At approximately 2 p.m., Friday, June 2nd, 30 local, county, and state police appeared at my residence claiming Edward Kennedy as a sovereign citizen. End quote. Okay, so we have an update in the Edward Thomas Kennedy situation already. Yesterday, we talked for 2 hours and 42 minutes about the lawsuit that Edward Thomas Kennedy filed against Lehigh County and Sheriff Hanna here in my county in Pennsylvania. Now we have the lawsuit where he sues Schuylkill County, which is where the alleged harassment charges and bench warrant and everything issued from. Tactical has read through this quickly, so if you could direct me any place that I should start other than the beginning.
The beginning is good. Most of the footnotes can be skipped, but it gets fun pretty quick.
Okay.
I would skip over this stuff that's a repeat from his last 8 lawsuits.
Okay, I will do my best. Take judicial cognizance. Under federal rules of evidence, the 2 pages of evidence, Exhibit 2, is self-authenticating under Rule 902.2, faxed to State Police, Fogelsville, Pennsylvania, and verified as true by Pennsylvania Right to Know Law Officer Johnston in a signed letter to Plaintiff Kennedy. Federal Rule Civil Procedure 4D provides that a plaintiff may waive service, and he asks him to waive service. We talked about this yesterday. Requests a judge to be assigned to administrate the case that obeys the rule of law and obeys his oath of office. And then he puts this section about how you please don't dismiss my case because I'm allowed to file a case and you have to let me file a case. And here's all the reasons why. In loving memory of Thomas Patrick Kennedy, who risked his life in a small ship in the middle of the Pacific Ocean in the U.S. Navy during World War II, rescuing injured soldiers during battles of was, so that his oldest son, Edward Thomas Kennedy, plaintiff, would have access to justice in a true court of record in our constitutional republic. Kennedy believes that his father and defendant Casey's father were true friends, and that their mothers are still friends. Kennedy believes Casey's life is touched with alcoholism. In fact, for a jury at trial to adjudicate, to explain her motive and or story.
So I have questions.
What?
He's flourishing hardcore, isn't he?
Okay, so Maria Casey is the Schuylkill County Clerk of Courts. Is that what he's talking about?
Yes. Also,
Okay.
You might need a hat for this.
I might need a hat. Oh, should I I'll put this tinfoil hat back on.
I have a legitimate law question. There's a lot to unpack there.
Yeah, okay.
If he's accusing her of alcoholism and she's not an alcoholic and he were doing this outside of the courts, that would be kind of defamation.
Yeah, it's a kind of defamation and it's especially defamation if it results in actual damage. I don't know that it will result in actual damage, but and I believe because she's a public official, it has to be done with malicious intent.
Well, my understanding is that he's implying that she didn't do her job correctly because she's an alcoholic.
Oh, okay.
So,
okay.
But enough. If you file a lawsuit, can you be sued for defamation for things that you allege in the lawsuit?
Yes, probably. The last time I read about that, someone on the internet was trying to cite the litigation privilege, and so I had to look up what in the world is a litigation privilege. It's like letters back and forth and documents you might exchange during litigation can be designated as confidential, and there is sort of an automatic level of confidentiality for those documents between litigating parties. That's it. That's litigation privilege. So, yeah, putting defamatory or untrue things, let's just speak conclusory for a moment. Putting defamatory things into a lawsuit is defamatory and can result in a defamation lawsuit, especially if there are actual damages to be claimed. So he once again talks about the national emergency. December 2017, the United States president issued an executive order titled Blocking the Property of Persons Involved in Serious Human Rights Abuse and Corruption. We talked about this yesterday. This executive order declares a national emergency and gives the Secretary of Treasury and other mechanisms to seize the property of certain people who have been found to be guilty of serious human rights abuses. So he cites this seemingly to hold this executive order against, I guess, the county of Lehigh and the county of Schuylkill and such. That's not quite how it works. Like I said, it needs the approval of the Secretary of Treasury and the Attorney General of the United States and the Secretary of State, I believe.
So I'm reluctant to give Mr. Kennedy ideas, but I would like to note that declaring national emergencies has been somewhat abused. Since 1979, the United States presidents have declared 58 national emergencies, of which 31 are still pending. So national emergencies are used somewhat casually.
And then, yeah, well, here he again casually states that effective January 1st, 2019, the nation is under a national emergency and military law.
I missed that memo, I have to say.
Okay, the president can declare a national emergency as to a specific thing, like a California wildfire or Hurricane Katrina or whichever the one was in Puerto Rico. Or the one that hit New Jersey. Those are common national emergencies to move funds and move troops and, make a federal thing of the emergency. That does not automatically mean that we're under martial law. And I'm pretty sure I would have heard about it if we were under martial law.
I can literally see the U.S. Capitol from my house, and I have to tell you, I have not seen a lot of military officials on the streets with guns. So I don't know what he's talking about.
We are not under military law. We are not under martial law. The president previously issued a executive order that amended some of the manual for courts martial. That's not the same thing. A military tribunal would be involved with a court martial, and a court martial does not have anything to do with martial law. Although if martial law was declared and you committed a crime that fell within something under that you were under martial law, yeah, you'd be talking to a different court system, very possibly, than if you were not under martial law and committed the same act. I actually don't know how all of that works, but I can tell you with 100% certainty, we are not currently under martial law unless it was literally just declared as I'm saying this, and it hasn't gotten back to me yet. But this assumption that we're under martial law is false.
Yeah.
So he talks about trespass of the case again. Suing them and basically for injuring his person. He does so under RICO again, claiming without evidence yet that they are guilty of some sort of Corrupt Organizations Act violation, failure to provide a Republican form of government, intentional infliction of emotional distress. We definitely went over a lot of the same stuff. Here, he finally gets into some of the accusations, signed a fake bench warrant, failed to properly notice Kennedy of the matters before the Court of Common Pleas in Schuylkill County, Pennsylvania. And, okay, so yesterday we went to the UJS portal and tried to look up his violation in Lehigh County. Maybe we should do the same thing today and look up what happened in Schuylkill County. What do we think? It was for harassment, wasn't it? So it would be in the magisterial courts. So that was 293, I think, was the case from yesterday. And so, yeah, here's where there was a bench warrant issued. I think we went over this a little bit yesterday. In Pennsylvania, if there was a charge, he would have received information about the charge in the mail, possibly be even served with the charge by the sheriff. And then if he didn't respond, they would send more letters and then eventually send the sheriff out to serve him personally. And if he still didn't respond, a motion to dismiss, or excuse me, a motion for a bench warrant would be granted, and then they would come and arrest him at some point. It doesn't happen quickly. They don't really, it's not like, that the judge stamps the warrant and then they come running after you, unless you've committed an egregious crime that really requires them to respond. And this is all in the judgment of the chief law enforcement officer. So if they're not doing something, you want to talk to the chief law enforcement officer. These are people, and they can make decisions and they can make mistakes, and they can also make things that are more than mistakes and be intentional and all that. So what Mr. Kennedy is complaining about here is something that someone could do wrong, but this so far seems like they've done it correctly. And a bench warrant was issued, and they came out to his house, and he hid in the bedroom, and then eventually they found him at Target a few months later, and they arrested him there. He spent 3 days in jail in solitary confinement, probably for his own good. And then he was released after either posting bail or getting arraigned by the judge, and the judge saying, okay, well, we don't mean to keep you in jail, but we're going to revoke your previous bail and you now owe us $5,000 or something like that has happened. And there's also a couple other things on this docket here. Let's see, this one was from 2/27/2017, but there are ones after this. So let's see what these are all closed, but let's look at them. So this is a different arresting officer, $5,000 bail. And this is another harassment charge from 12/13/2016. And it looks like it also was dismissed. It was also dismissed under his speedy trial motion. Under Pennsylvania law, they have a year to prosecute you for a thing, and if you don't do it within a year, then the defendant can get the thing dismissed for failure to have a speedy trial. So that's what this appears to be dismissed under. Here's another one. This is also a Petrus thing, but this is a different case.
Our friend Petrus.
And it's another harassment thing. And then it says he was present for that hearing, but then not present. Bail was set. There's a motion to dismiss. They denied the motion to dismiss. Emergency motion to dismiss. Denying motion to dismiss. Granting discovery. So it seemed like this was eventually dismissed. He files this order or this motion for take judicial cognizance, file on demand, which is also denied. They dismiss his objection. It looks like he hasn't paid his court costs, which you still have to pay for a lot of times. Now, if he hasn't paid them and the thing's been dismissed with prejudice, yeah, he probably didn't have to pay for that. But if you pay for it up front, a lot of times you don't get your money back. We've often told people not to pay for them up front.
He put in a notice of appeal, even though he got his case dismissed?
Yeah.
Okay.
Let's
good.
go back to this. So even though his case was dismissed,
Wait, so he's
all the way down here to the end.
Voluntarily dismissed.
So this is 404. That's dismissed. Then yeah, there's a notice of appeal. If you appeal a criminal conviction, they can retry your criminal conviction, right? Like, so he's just undoing his Rule 600 motion, right?
I don't know.
He might be.
I
if he successfully goes into the appeal, he might be undoing his Rule 600 motion.
Yeah, because he did this with the other case as well. That he did the Rule 600, and then the judge dismissed it, and then he tried to. Then she ruled that his objection was moot because the case was dismissed.
Yeah,
and then he's trying to appeal her ruling that his objection was moot. Blackleaf is rolling his eyes so hard right now.
So he had his case dismissed because he didn't get a speedy trial, and now he's trying to appeal?
Well, so if I was to be so bold, I think what he's getting at is he doesn't like that his harassment charges weren't prosecuted to the fullest extent of the law, and therefore were dismissed under this right to a speedy trial thing. And because they didn't complete that process or whatever properly, that it must mean that there's a rights violation on him and he deserves some kind of compensation, etc., or recognition that they harmed his rights. He's going to find out the hard way that that's not how the criminal law works. Yes, it feels like it's a major injustice when the police charge you with a crime and then you have to go and prove your innocence, but you don't really have much more than the ability to complain to the officer's, I don't know, association, union, the formal complaint process established by the city or whatever. You can go complain about that officer or that person. And certainly you can make a civil rights claim that someone violated your rights. That's apparently what he's doing here. If I was a judge in this case, I would sort of convert this to the very basics of his claims, like a 42 USC 1983 civil rights claim, and then, apply that standard and see if he's even remotely close. This could survive a motion to dismiss because he sort of has stated a claim here. He said that they violated his various rights, and he's, you can parse it together. It takes hours, right? But you can parse it together and figure out what he's getting at. However, was it a rights violation? Then when you get to the actual nitty-gritty facts of the thing, was it a rights violation that they charged him with something and then issued a bench warrant when he didn't show up to court?
No.
It looked like he was present for other cases, so how did they have the right address or information for those cases and then somehow didn't have the right information for this case? I don't necessarily see the facts where he says that they failed to properly notice him. What is this Exhibit 2? Let's go down to this Exhibit 2.
So I've redacted the address from Exhibit 2.
I see it. Okay.
But it is not the address that he lists as his home address. And I believe later he says maybe it's like a UPS store or something like that.
Okay, but what about these other cases, though? There were other cases. Huh. All right. So, I mean, that's a valid thing, but then when they don't have the right address for you, then there's that time where they send the sheriff to your address, and apparently they did find him then. And it looks like Pennsylvania Rules of Criminal Procedure 150A5B says that you can be held for not longer than 72 hours. He was held from August 28th to August 30th, according to the court documents, which could not be longer than 72 hours. Three days
Right.
would be 72 hours.
Right.
So he would have to be held from 12:01 midnight to 11:59 for it to be 71.9 hours. So he was not, according to the records, held for more than 72 hours. Now, that's an egregious thing. Yeah, I get it. You don't like being sent to jail for 3 days because you didn't respond to court papers about harassment. You shouldn't be going to jail for harassment. That's not what's happening here, though, right? Oh, whoa. Here we go. Dear Reverend Kennedy, Chevalier Reverend Edward Kennedy. That's what CHEV means,
Yep.
right? Chevalier?
Yep.
What's that?
There's a lot of time that I ask, what's that in this lawsuit?
So a chevalier is a surname of French origin during the Middle Ages when it denoted a knight.
Okay.
Yes. Now, when he sent his letter, I feel like I should have
Knight Reverend Edward Kennedy.
I feel like I should have a whiteboard up right now and I'm drawing lines between different documents. But in the document that he sent to the Catholic Church saying that he was no longer going to be a member, he said that he was no longer going to be a priest or knight of the church. And so my understanding is his use of Chevalier Reverend is that as someone who was baptized Catholic, that he is therefore a knight and priest of the church, I think.
What?
Okay, so he made a request. He made a request under Pennsylvania's right to know law, which I've used before. It's a very simple law. You just basically have to make a request to the proper party, and every county or municipality or whatever has to make available an email address or a proper procedure for requesting under the right to know law. And then they have a certain amount of time to respond and all that. So this is M. Judith Johnston from County of Lehigh Human Resources responding to Chevalier Reverend Edward Kennedy. I am responding to your right to know request of December 19th, 2017, sent to Sheriff Joe Hanna to review your request for the following, quote, to see in person all police records and documents from an incident that occurred at my residence listed above at approximately 2 p.m. Friday, June 2nd, including vehicles marked Lehigh County Sheriff, when approximately 30 local, counties, and state police appeared at my residence claiming Edward Kennedy as a sovereign citizen. I am most interested in the following: who gave such an order, by what authority, and who was here and why. All evidence and authority / statutory elements. She, the writer, Judith Johnston, is denying your request to see police records, as the request is an exemption under records related to a criminal investigation. Regarding your request as to who gave an order and by what authority, I'm providing you with a copy of the bench warrant signed by Judge William E. Baldwin, dated April 12th, 2017, deputy sheriffs were at the residence to exercise their law enforcement responsibility to execute a bench warrant signed by Judge Baldwin. You have the right to appeal this decision on the open records thing by such and such a time, and it advises on how to do that. So they wrote back with a copy of the bench warrant and explaining that they were there to execute said bench warrant that was issued by Judge Baldwin, which is then this bench warrant. It was issued the 12th day of April 2017. So let's go back to this report. And so if we go down to the summary here, it looks like the original papers received from lower court, the information was filed, and then a month after, pretty much literally 30 days exactly after the information was filed with the court, then the motion for a bench warrant was made, because 30 days after it was filed would have been when either mail was returned or there was no response from the defendant. That's a normal thing. They granted the bench warrant on April 12th, and then June 2nd was when they finally visited him at the home. However, they didn't get him then, so he was obviously on notice that the case had occurred and that he should be contacting the court as of June 2nd. But he wasn't arrested on June 2nd, and he didn't take care of the issue with the court between June 2nd and August 28th when he was arrested. And then here, August 30th is when he was finally released by posting bail and having bail set by the judge. So that's how that happened. It didn't happen as a violation of his rights. It happened as a you didn't show up to court thing. And that's what happens if you don't show up to court. They come and get you eventually.
I gotta say, the only times I've seen you like this genuinely surprised are in Edward Kennedy's videos. Like, you every time it's like oh, like you just have this look on your face like whoa, like this guy throws you curveballs, you know. And this is the only time that I've seen like real like super surprise from you.
Yeah.
I kind of want to have a what counter from the VOD yesterday of like all the times that Leonard said what.
Yeah, it's one of those.
Like for the most part, we cover like standard lawsuits and litigation, and and you're like, okay. But everything in these cases is always like, what is he talking about?
It is a rabbit hole
like,
that we just have to keep digging to find what's going on.